For real this time, we're live. And I was talking on for about 7 minutes, and then Patrick on X reached out to me and said the live stream was private. So had to pour through the various functions of the live stream to ensure that we were public. So good morning. We are public and live. It is Illinois in Focus Daily. I'm Greg Bishop. Thank you so much for being with us. A little bit later for a start. That's because I was talking for 7 minutes and noticed something wasn't right, but then we got the official word from one of the listeners, so I appreciate you guys being loyal with us. Each and every weekday morning, Illinois in Focus Daily. I'll be sure to put that on my checklist before we launch, that indeed. Double check to make sure it's public. All right. So good morning to everybody joining the chat room. Really do appreciate you guys being here each and every weekday morning. But also don't forget, you can join us in the podcast. If you can't watch live, you can listen to us anywhere. Just search Illinois in Focus with America's Talking Network. So greatly appreciate you guys being here. A little bit of a preview of what we're going to be talking about. Last segment, we'll discuss abortion laws that the governor signed today here in Illinois. He signed those yesterday in Chicago. We'll also talk with Todd Vandermyde. I had a conversation with him yesterday about the impact of the Maryland gun ban challenge, eyeing the U.S. Supreme Court, and what that means for Illinois' challenges. But up next, we'll talk about Sangamon County Sheriff Jack Campbell refusing calls to resign. Those calls coming from the likes of Governor J.B. Pritzker and others. So that's what's coming up here with Illinois in Focus Daily. Again, thank you guys for your patience with the live show. But if you're listening on the podcast, you get that anytime you want. Just search America's Talking Network, Illinois in Focus Daily, and the Center Square. And you'll find me, Greg Bishop, with you each and every weekday morning here with Illinois in Focus Daily.
And I called for the sheriff's resignation because the sheriff has failed. He has failed to explain how he ended up hiring this deputy sheriff who has been fired from other departments.
Why haven't you met with the Masseys? It's really not that hard. They would be willing to meet. Why hasn't he met with them? I've met with them. The lieutenant governor met with them. He's done none of those things. We've waited and waited and waited, day in, day out, nothing, and now he's simply on defense.
Again, Governor J.B. Pritzker, a couple of different times yesterday, having to react to questions of him calling for Sangamon County Sheriff Jack Campbell to resign. Campbell saying he's not going to resign. It's Illinois in Focus Daily. I'm Greg Bishop. July 6th, we had a police-involved shooting in Springfield. A black woman, Sonia Massey, calling police in the early morning hours of a suspected prowler, and then Sangamon County Sheriff's deputies arrived, and they ended up, one of them, shooting Massey inside her home. Of course, we talked about those details, and the body camera footage is gruesome, but clearly the former sheriff's deputy was fired shortly thereafter and charged with murder, Sean Grayston. So clearly there's some questions as to his past employment record and what kind of response there is from the Sangamon County Sheriff's Department. So what kind of response should there be statewide? We had this issue go all the way up to the highest office with President Joe Biden making statements late last month. You have Vice President Kamala Harris actually having a conversation with the Massey family. You have the governor of Illinois, Governor J.B. Pritzker, saying he and the lieutenant governor both met with the Massey family. But Sangamon County Sheriff Jack Campbell having yet to meet with them. We'll read an entire statement from the sheriff in a moment. But yesterday in Chicago at an unrelated event, Governor J.B. Pritzker was asked what kinds of state policies need to change. Is there a bill or something like that to address this entire situation? Here's the governor.
That's a little inaccurate. We had a conversation about it. There wasn't a bill. There were some ideas that were discussed when I visited with the Massey family. But let me just begin by horrific fashion. And I can't get past the idea that we have to do more to protect people. We've done a lot, and I want to credit the Illinois State Police who did the investigation in a very short 10 days. That's hard to do. To do an investigation because you've got to do a lot of interviews. It's a fulsome endeavor, and came to the state's attorney, who immediately was able to get a grand jury to file charges. So it happened in a quick fashion as it can, but it never should have happened in the first place. And I talked to one of the black elected leaders in Illinois just after it happened to get her perspective, and she shared with me, because I was so upset about it, she shared with me that even though we haven't made enough progress, she said to me that in years past there never would have been an investigation, there wouldn't have been a body cam, no one would have known what really happened, and that the maybe the silver lining, if there is a silver lining in this, is that someone is being held accountable. And yet we have much more to do. So, yes, I sat with the Massey family and promised them that we would look at every avenue to determine how we might prevent this from happening to anyone ever again. And I called for the sheriff's resignation because the sheriff has failed. He has failed to explain how he ended up hiring this deputy sheriff who has been fired from other departments. He failed to put forward reforms that clearly need to be made, training and other reforms, and still has failed to meet with the Massey family. That seems to me, and I'm not saying that's a fireable offense to not meet with but that just seems outrageous to me. At a minimum, listen to them, hear them, and then hopefully take action. So that's why I called. And the lieutenant governor and I did that together, just to be clear.
So again, that's Governor J.B. Pritzker earlier in the day yesterday up in Chicago, sharing his thoughts about Sangamon County Sheriff Jack Campbell. While those comments were being made, Campbell sent out a statement, and here's the statement. We'll read it to you in full. Statement from Sangamon County Sheriff Jack Campbell. The Sangamon County Sheriff's Office continues to grieve for Sonia Massey and her family. While our grief cannot compare to the pain of the family, our office is trying to heal from within. All employees of the sheriff's office feel betrayed by one of their own. On 4 separate occasions, the sheriff says, I have requested to meet with the Massey family through intermediaries designated by the family. My requests have been rejected or not accepted. I am still willing to meet with the family, the sheriff said. The sheriff's office is willing to modify our hiring practices in order to prevent an incident like this from occurring again. However, before changes can be made, it's important to identify the problem. We have used a process that we believe was consistent with statewide standards. If these standards are deficient, we would advocate a change at all necessary levels. Campbell's office goes on to say, we're working diligently to gather all the facts in order to make intelligent decisions and to avoid making changes that are unlikely to lead to meaningful results. I agree with the governor's comments from yesterday. And again, this is Campbell's reaction to Tuesday's comments that the governor made at an unrelated event. And while the governor was making those comments here in Springfield and up in Chicago, you had Campbell release the statement. But it goes on to say, I agree with the governor's comments from yesterday, and that would be Tuesday's comments. There are still questions. I have worked tirelessly to make all the facts available to the public as swiftly and transparently as possible. I'm committed to working with our community and elected leaders to improve not only the sheriff's office, but also hiring standards on a statewide level to prevent a state agency from certifying a similar law enforcement officer 6 different times in the future. We need to unite and heal. That one responsibility is in the one responsible is in jail and will never work in law enforcement again. Calls for my resignation are nothing more than political maneuvering, Campbell says, during a tragic event and only hurts the good citizens of Sangamon County. Campbell goes on to say, I was overwhelmingly elected to lead the sheriff's office through both good times and bad. I'm fully prepared to continue leading my office and serving the residents of Sangamon County through this difficult period, ensuring we learn from this tragedy and work toward a better future. So again, that's the entirety of Sheriff Jack Campbell's comments. And that came as the governor was making comments saying that the sheriff should resign earlier in the day yesterday. But then the governor went down to Springfield here in central Illinois, the state's capital, and he was unveiling the butter cow. All right, it's the state fair time. You've got the butter cow. You've got the ribbon cutting that's going to be happening today. You've got all the agriculture enjoyment and the fair food and the concerts and the butter cow and the tractors and the livestock and the butter cow and a whole host of other things, right? And if you get a chance to come down to Springfield, you can check out the butter cow. But the governor, he, of course, after unveiling the butter cow, he was taking comments and questions from members of the media where he again was asked by a Springfield base of journalists about the Sonia Massey shooting and about getting some response to Jack Campbell's statements that were released earlier in the day. So again, here's the governor in Springfield with some comments furthering his call for Campbell to resign.
The Massey family has said, I think publicly, that they've asked for a meeting with the sheriff, and he has not been forthcoming with a meeting. Now, he says that he's offered multiple times to meet, but the Massey family will tell you they have not been offered the opportunity to meet with him. It's been a month. We should have seen already a meeting with the Massey family. If he's reached out, he hasn't done a very good job because the Massey family hasn't had the meeting that they've asked for. Second, as you know, the deputy sheriff resigned from every position, held positions for less than a year, sometimes for just a few months, 6 times resigned. And I ask the question simply, and I think people have for a month now, what did the sheriff know about his background? Why didn't he do more work on his background before hiring him? And a month has gone by. Again, a lot could have been said about that over the course of this month. And the final thing is, this isn't about politics. It's about bringing people together in Sangamon County and making people feel safe. And it's the sheriff's job to make people feel safe. And he's done the opposite of that by not answering questions, by going to a church and beginning his remarks by saying, I'm not resigning, like as if that's the first thing people want to hear. And then there are signs that have been put up about saving him, not doing something about the murder of Sonia Massey, but about saving his political career. So I think he's the one that's played politics. It's time for him to go.
Some people may point out, where's the governor's calls for, say, the Cook County sheriff to resign because of the continued violence in Cook County, where you've got shootings on the street every weekend, every day practically, with dozens of shootings every weekend, and young children being killed in what appears to be gang violence. Obviously a lot of commentators all across the political spectrum here on this controversial issue, but the governor went on to describe the sheriffs as inept in Sangamon County because of the hiring practices. And I'll just go back to what Sangamon County Sheriff Jack Campbell had to say here in his statement. He said they're working diligently to get all the facts in order to make intelligent decisions and to avoid making changes that are unlikely to lead to meaningful results. I agree with the governor's comments from yesterday. There are still questions, and he's worked tirelessly to make the facts available to the public, and they're willing to modify their hiring practices in order to prevent an incident like this from happening again. However, before changes can be made, it's important to identify the problem. We've used the practice we believe is consistent with statewide standards. If these standards are deficient, we would advocate for changes at all necessary levels. What about those hiring practices? Governor Pritzker being asked about that.
This isn't about state policy. The sheriff of Sangamon County can do what he thinks is the right thing to do to hire the right people to work for his department. The state shouldn't have to set policy for him to hire, to do background checks, not just background checks, but reference calls on the people that they're hiring. Look, I don't think we know what he did because he's been unwilling to tell us. So when he says he's followed some state standard, if the state has it's not the standard that each person who is in a hiring position across the state should be thinking about. They need to be thinking about the care and safety specifically of people in their county. And so I just want to know, and he's been unwilling to answer the questions. Again, if he had been willing to do these things and act, and he's had a month, I think there would be a lot less frustration and a lot more, perhaps, a sense of safety. But none of that was done by this sheriff.
So the back and forth continues. Will there be some kind of policy decisions made at a statewide level to ensure that, the governing body of how police get certified, however that is? I imagine we'll hear a lot more about all of this. It is Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell, and join us each and every weekday morning for Illinois in Focus Daily. Find the podcasts wherever you get your podcasts. Just search Illinois in Focus.
I think it's so bad, they've actually done us a favor because now it just so flies in the face on the common use test. Modern guns are protected. All the things that have been reiterated through Heller, Bruen, and so on. I think this thing is just so bad that they're going to take it. And I think it's time that after over 15 years that this issue gets hammered out. So I think we've literally got 9 more months.
That's gun rights advocate Todd Vandermeide in a conversation I had with him yesterday, reacting to the case out of Maryland and the gun ban there being upheld by an appeals court on final judgment, and the trajectory of it going to the Supreme Court of the United States. Welcome in. It is Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell. Join us each and every weekday morning as we break down stories that are impacting you here in the land of Lincoln. Find the podcast anywhere. Just search Illinois in Focus, and you can get the newsletter with the Center Square. Go to thecentersquare.com. So we talked yesterday about the ruling earlier this week out of Maryland in a federal appeals court upholding the Maryland gun ban and what that means. This is the Bianchi case. And for those who've been tracking these cases across the country, not just here in Illinois, we've seen that there are different cases at different stages. Well, the Bianchi case was in front of an appeals court on final judgment. This had already gone back to the district courts after the Bruen decision, the New York State Rifle and Pistol Association v. Bruen out of New York, where the U.S. Supreme Court made it clear that in order for gun laws to be constitutional, they need to match up with text, history, and tradition, going back to founding era understanding of the Second Amendment and why it's necessary as a right, fundamental right, the second right on the Bill of Rights, right after free speech, freedom of assembly, free religion, and so on, freedom of the press, for example. So you've got this ongoing question of, well, what kinds of weapons or firearms can government ban? Illinois has a gun ban and a magazine ban in place. It's been in place since January of 2023. Here we are now in the second week of August of 2024, and lawsuits have been filed, and they've gone all the way up to the U.S. Supreme Court, but they were only on preliminary grounds in the state of Illinois' challenges. Maryland's case, much further along. What does all this mean for the Second Amendment? Todd Vandermeide here, again, a gun rights advocate in the state of Illinois. He's also been a consultant on some of the cases in the Southern District of Illinois that are challenging Illinois' gun and magazine ban. So he has a keen understanding of the variety of factors involved and all the arguments that are being made, in particular what the Maryland case being queued up for the Supreme Court ultimately means for the Second Amendment.
Well, a couple of things. This judge must have read the Seventh Circuit opinion in our cases and jumped off his meds and put it on steroids. There are a whole host of things that are wrong with this case. I have a bunch of cliff notes. They have doubled down on the concept that in order for a firearm to be protected, it must be used in self-defense. That's not the standard. And they're saying possession for self-defense is not enough. It has to actually be used in some way. They sit there and talk about criminal misuse of firearms, and that they get to the point that, so much so that if criminals use something too much based on their standard, it can be banned according to that. They jumped the shark in this thing in a way. So if you remember during the arguments, Justice Easterbrook brought up the concept of man-portable nuclear devices that were tested out in the Vietnam vintage. Well, here, Judge Wilkerson, in his opinion, goes beyond that and talks about umbrella guns that would fire ricin pellets and brings that whole notion in here. It's crazy. They talk about, they go how 50 caliber firearms are so dangerous because of their ballistics, and then they import all the ballistics of a 5.56 or 2.23 caliber rifle into this and try to equate that for dangerousness using ballistics. Yet they don't ever talk about pistol caliber carbines, obviously ARs that shoot 9mm or their equivalents. It is just they throw a whole bunch of interest balancing in there. Even though they try to hide it, they talk about all the mass shootings that have happened. They just wear that. This is like a gun control screed for the best of it. They talk about how technologically there's a small thing in Heller about, such technological advancements may force us to look at things a little differently. And they basically say that semi-autos were not around at the beginning. Therefore, you can use this exception and try to walk in a bunch of other stuff. They go back to the traditional Bowie knife argument that Bowie knives were regulated at the time of the founding as some sort of ultra dangerous knife or whatever. And because of that, they sit there and say that, therefore, that leads to the regulation under the Rahimi principle of a general doctrine. And then they cite all kinds of laws from 1839 to 1923. They are leaning real hard on using 1865 as the time to be looking at for the appropriate laws. And then they draw a direct line from the Bowie knife bans of the time of the founding to the National Firearms Act of 1934. And they use that to justify what they did. Basically, these are not arms, they're military features. Take them out of that category. They lean real hard on the M16 analogy that the Seventh Circuit used and put it on steroids. And it's 65 pages long of just an anti-gun manifesto of why. And I think it's so bad, they've actually done us a favor, because now it just so flies in the face on the common use test. Modern guns are protected. All the things that have been reiterated through Heller, Bruen, and so on. I think this thing is just so bad that they're going to take it. And this now tees us up. They said that there was no reason for a remand. They said that it's so bad, I think it's going to help us.
So again, that's Todd Vandermeide sharing some of his initial thoughts here on the Maryland case and all the particulars about the Maryland case, essentially upholding the ban on semi-automatic firearms. But if you look at, Maryland's case heading to the Supreme Court, Illinois' cases went to the Supreme Court, didn't they? Well, they were denied to take up a certiorari petition because it wasn't a ripe case. And what does that mean? Well, listen, if you've been following all of this, hopefully you understand the difference between a final judgment and preliminary action. Preliminary action is just an initial request of plaintiffs to take a certain action while the rest of the case is dealt with. So we had in the Southern District, for instance, this is April of last year, if you recall, the 6 days that the state's law was enjoined in Illinois from being enforced. So people went out and bought a whole bunch of semi-automatic firearms and magazines over certain capacities for 6 days before an appeals court reversed that preliminary injunction. All of that was the first kind of steps. It wasn't on final judgment. So those preliminary actions went up to the appeals courts, and they ultimately sided with the states. And then plaintiffs in these cases went to the Supreme Court and said, hey, on a preliminary basis, take this case. Well, last month, if you recall, you had Justice Clarence Thomas deny taking those cases, essentially saying that these are all on preliminary actions, and the Supreme Court's looking forward to having a detailed record to actually make a ruling on this case once and for all, on this idea, not just Illinois' case, but the idea altogether of a ban on certain types of firearms. And can the government go that far? And I think this is going to be important, especially heading into the November election. Will we have a determination before then? I don't think so. But Kamala Harris and her vice presidential candidate, they have essentially said that there needs to be a ban on, quote, semi-automatic firearm or assault weapons, they call them. So background of, Illinois' case going up to the Supreme Court denying that, it was because it was on preliminary grounds. Vandermeide yesterday, when I talked with him, he said that the Maryland case is on final judgment. And that may be exactly what Clarence Thomas is looking for.
Well, look at what Clarence Thomas said. He said they wanted a case that was done on the merits with a record. Here, they've got a record. And now they've got an egregious finding by not just a court of appeals, but an en banc court of appeals. That is all the judges. So there is no 3-judge panel that you then appeal en banc to see if you get they're playing the games in the fourth that they've been playing in the Ninth Circuit on issues. So yeah, the next stop is the Supreme Court of the United States. And with Illinois, we've got a trial. Now, if you'll remember, Judge McGlynn issued a order, and he had a kind of a checklist of things that he wanted to hear about. Great. I think you line that checklist up with what this judge wrote in this opinion. And we know the state is going to glom onto all these arguments. They've been making some of them. They are going to glom onto all these arguments. And this just gives us, it's like an open book test. We've been given the answers ahead of time to deal with them. And I expect our attorneys will deal with all of these just like this.
And tons of other cases across the country. You've got, this week a district level New Jersey court saying that their gun ban was unconstitutional, but the magazine ban was constitutional. That's at the district court. You've got a case that's held up over in California. I believe that's in the appeals court, but I don't even think they've had a hearing yet. You've got all these other cases across the country. The Maryland case being the first that's going to actually go to the U.S. Supreme Court on all of this.
This case is only a gun ban. It's not magazines. If you'll remember when we did the Illinois stuff, 3 of the cases down there are guns and mags. Our case that I'm involved in with FFL is guns and parts, repairs. Okay? And I haven't studied the Maryland law in that depth to talk about, how the two relate. Obviously, I don't think Maryland's list is 170 guns long, but they do have the generic features test that is different than ours, but close. Theirs is a dual feature test, not a single feature test. So when you look at all that, and don't forget, and they dropped another case yesterday about felons in possession and serial numbers that didn't go our way, but there's a whole nother line about that. But don't forget, this en banc panel also has the Moore decision, the Maryland FOID card case.
So there's a lot of other cases out there impacting Second Amendment rights, including cases in Illinois challenging Illinois' FOID card case in federal court. Not much movement there. But when it comes to the gun bans, Illinois, we have a bench trial set for September 16th in the Southern District of Illinois Federal Court. Could the judge there issue a final judgment and say the law is unconstitutional and ultimately put another injunction on the law while it goes to the appeals courts, and they may reverse that injunction while they take the case under consideration, and then who knows how long that takes before it gets to the U.S. Supreme Court. While we're waiting for that to play out here in the state of Illinois, Maryland's case is up first. Again, final comments from Todd Vandermeide.
They are Seabiscuit. They are out in front, and they're there. And it's a final judgment. It's all on the merits. It's all on the findings. Which is what we wanted. So now, I think that what's interesting is there's a clip from Justice Gorsuch at his confirmation talking about the Second Amendment and Judge Wilkerson, who had authored the prior opinion on this issue out of the Fourth. And so I think that it kind of, leads you kind of where Gorsuch is. You got Alito, you got Gorsuch, you got Thomas, you got Kavanaugh, who sat there and wrote a dissent in Heller 2 on semi-autos. That's 4. I think you're going to pull Barrett and the Chief along with it. I think it's time that after over 15 years that this issue gets hammered out. So I think we've literally got 9 more months.
Again, thanks to Todd Vandermeide for talking with me yesterday. Clearly an issue a lot of people are interested in, and we will continue to cover that as it unfolds. It is Illinois in Focus Daily. I'm Greg Bishop. Thank you so much for being part of the program each and every weekday morning.
The 3 bills that I am signing today send a single, straightforward message. Illinois will always be a place where women have the freedom to make their own medical decisions.
It's Governor J.B. Pritzker signing 3 bills yesterday at a bill signing ceremony in Chicago. The measures deal with abortion and reproductive rights. And a lot of advocates there yesterday in Chicago standing with the governor, including Illinois Attorney General Kwame Raoul, Senate President Don Harmon, House Speaker Chris Welch, and various legislators that were involved in these 3 different pieces of legislation. So we could delve into all of what they had to say yesterday when they signed the bill, but I figured we would just reflect on some of the action in the debate on the House and Senate floor on these measures. So the 3 measures that the governor signed, here is State Representative Avalar talking about House Bill 581 in the House when it passed earlier this year.
Strikes the definition of hospital emergency services and redefines stabilizing care as explicitly including abortion when abortion is necessary to resolve a patient's injury or acute medical condition that is liable to cause death or severe injury or serious illness. It also prohibits the Department of Public Health from issuing a fine or for a violation if the same conduct has been the subject of a fine assessed by the federal government. It also removes the private right to action. This amendment brings the Illinois Hospital Association to neutral.
So the measure would essentially say that if there's a federal health care law that the Supreme Court overturned, Illinois would still have these policies in place. I believe the U.S. Supreme Court in June denied even taking that case. But regardless, the debate back and forth about this, saying that, it brings an element that's in place in Illinois right now, but it seems to impact medical decisions doctors may make. A Republican state legislator, Bill Howder, is a medical doctor, an emergency room physician. He reacted to this legislation on the House floor before it passed.
I've been practicing emergency medicine for 27 years. I've never been involved with a case or heard about a case where abortion was necessary to stabilize a patient. And if it happened, if it was needed, current Illinois law would not prevent it. So what we have here is confusion from clarity. This is what happens when lawyers try to practice medicine. Today we vote on another abortion bill that was conjured up in the last week from a shell bill with very little input from stakeholders let alone the citizens of Illinois. This bill adds conditions, confusion. It emphasizes abortion where it would never be considered. It'd be contraindicated, it'd be dangerous, and implies doctors, nurses, and hospitals must prepare to perform or offer elective abortions to resolve acute medical conditions of pregnancy. Or maybe not, I don't know, it's confusing. I hope Illinois physicians continue to provide care to both the mother and the unborn with the highest standards of medical care and ignore Illinois' abortion politics. Vote no.
So clearly, some conflict there on the House floor when this ultimately came up, and I think it's interesting to note that Howder, he says that this bill was a gut and replace. We see a lot of that going on at the state legislature, especially in the final weeks of legislative session. But still reviewing, going back into time and looking at these bills that ultimately passed, that the governor signed 3 abortion-related bills in Chicago yesterday, but we wanted to look at the floor debate, both sides of this, right? I mean, it's important to get both sides of all of these stories. So House Bill 5239, another measure that the governor signed yesterday, State Senator Selena Villanueva, a Democrat out of Chicago, carried that bill and explained on the Senate floor earlier in spring session what this bill does.
Thank you, Mr. President. House Bill 5239 prohibits any unit of government, including a home rule unit, from expending any resources to assist any individual or entity seeking to impose civil or criminal liability upon a person or entity for lawful healthcare activity except where necessary to comply with Illinois or federal law, or where an individual or entity is investigating conduct that would be subject to liability under Illinois law. It exempts location information and health records related to lawful healthcare activity from the Freedom of Information Act. It also establishes a cause of action against any offending unit of government with a 2-year statute of limitations after the cause of action is discovered. This is a bill and an initiative from the governor's office. It's a good bill.
And the governor, again, signing this bill yesterday, just to break down some of those things again, the way Republicans interpret this is it's a shield law, right? It says that people can't be, have their private medical information sought by out-of-state enforcement. Republican State Senator Jill Tracy, she reacted to this, asking questions about, does this include minors getting abortions? What about if a minor girl is abused by their stepfather in Missouri, and then they come to Illinois to sign up for public aid, and then that public aid tax dollars are used to perform a procedure to terminate a pregnancy that was caused by an abusive stepfather. I'm being very cautious in not using certain words that could trigger the algorithm a certain way, but ultimately she was worried about what this means for victims of these types of crimes, especially if they're coming in from out of state underage and the taxpayers seemingly footing the bill for this.
That Illinois taxpayers are going to provide these services at their expense to minor children without the knowledge of their parents. It's just astounding to me how we can put some of these together. And these scenarios are not some big conspiracy aluminum hat theories. They're happening every day. And everybody's watching Illinois, and we're giving them cover. And so to me, it's just wrong in so many ways. But let's not aid and abet criminals to take advantage of minors and at our taxpayer expense. It's just incredible.
So that's Republican State Senator Jill Tracy, again, expressing her concerns about that particular piece of legislation. Legislation, again, the governor signed yesterday. He signed 3 bills. So we've talked about 2 of them. Here's one, House Bill 4867. This is from State Representative Anna Moeller, Democrat out of Chicago. She shares what House Bill 4867 ultimately does.
House Bill 4867 includes complementary protection for the right to reproductive decision-making. Specifically, key provisions of the legislation include it adds a protection against discrimination on the basis of reproductive health decisions to all Illinoisans, giving them the freedom to make decisions concerning whether, when, and how to start a family without the fear of discrimination or retaliation.
She goes on to explain other elements of this getting added to the Human Rights Act in the state of Illinois, but State Representative Patrick Windhorst, Republican from downstate, he's the floor leader asking all kinds of questions, and he was concerned about the impacts on religious organizations that may be, for instance, crisis pregnancy centers. How will they be impacted by this? Will they have to, not discriminate against an employee, for instance, who wants an abortion or somebody coming in who wants an abortion?
Organizations that have a religious affiliation would be exempt under the definition of a religious organization. If a crisis pregnancy center fell under that designation, then they would be exempt, but if not, then they would not be.
Thank you. To the bill.
To the bill.
I believe there are some real concerns about the religious exemptions that have been raised by those organizations, and I'll be voting no. Thank you.
So there you go. Bills the governor signed yesterday that are now law impacting abortion, and unpacking what those laws ultimately are from floor debate earlier in spring session. It is Illinois in Focus Daily. Like, subscribe, hit that notification bell each and every weekday morning. Wake up with us and get the know-how of what's going on in the state of Illinois. Of course, today you've got the governor. He's going to be cutting the ribbon on the state fair. Then the state fair officially opens. But here is, I guess, a moment of zen. Your butter cow, ladies and gentlemen. Your 103rd Illinois State Fair butter cow. We'll leave with that. Have yourselves a wonderful rest of the day. I'm Greg Bishop. Like, subscribe, hit that notification bell. It is Illinois in Focus Daily. Get all the segments that you may have missed by subscribing to America's Talking Network on YouTube. Get the full podcast anywhere you get a podcast. Search Illinois in Focus. And also subscribe to the newsletter with the Center Square, thecentersquare.com. We'll see you guys back here to wrap up the week. Tomorrow, it's Friday, right? Have a great day. Illinois in Focus Daily.